Good morning, good afternoon, or good evening. This is Pamela, and you are watching Pam Entertainment TV, where we review movies, television series, and incidents in pop culture to see how those incidents may or may not affect our daily lives. Listen, I am going over Blake Lively's response. Honey, you see the title. We're gonna go, we're gonna read the letter that her attorney filed with the state of New York, Southern District of New York court in response to Baldoni's letter. So we're going to read that. And honey, and I'm going to try to read it in a tone that I believed that it was written in, but I'm not sure. Y'all, I want to shout out. I get to communicate with people who are following this case. I don't know who they are, but they get out here. Shout out to social media and internet sleuths. Shout out to Leanne Newton. She is at Kiera J 2001 on Twitter X. Y'all follow her. She is covering this case as well. She went down and broke uh, the Green Lantern and the It Ends With Us. It ends with us rooftop scene, and saw that the Green Lantern uh dance scene were similar in there. She's got a complete thread and breakdown on her X account. Y'all follow that because it was some interesting reading, some interesting parallels and similar things going on with that. With us as these internet sleuths, we have come to that don't seem to be like a coincidence. It's not a ha ha funny. It's a ha ha hmm type situation. So y'all go check her out. So I am on her X page, and she has a copy of the letter. And let me make sure I'm sharing my screen. That's so small. Hmm. Let's go here. It's not necessary that I be so big. All right. So you see it on the screen. Sometimes it's not as big as it needs to be, but that's okay. But read her little a note over here. This says Lively's legal team have now responded to Baldoni's earlier letter regarding the subpoena. It's officially a bitch right now. Oh my goodness. So let's go ahead. So this was drafted on February 24th. I'm reading it off my iPad. Uh, and it's to the Honorable Louis J. Lyman. I know he is sick of them. I know this man is sick of them. You hear me? It says, Dear Judge Lyman, we write to address Wayfarers Party's letter to the court, docket number 93, in connection with the court's February 19, 2025 order taking under advisement the Wayfarers Party's letter motion for discovery, docket number 85. That letter motion concerns purported objections to third-party subpoenas served by Ms. Lively. On February 20, 2025, the parties held a meet and confer, during which counsel were able to agree that removing any request for locational data from the subpoena and providing express language to clarify, as had previously been communicated to the Wayfair parties, that request applied exclusively to non-content information would allay certain of the Wayfair parties' concerns. Nonetheless, counsel for the Wayfair parties continued to maintain that the subpoenas were overbroad. Counsels for Miss Lively expressly requested that the Wayfair parties identify any modifications that would allay their concerns with the subpoenas. Putative overbreath, but the only limitations that the Wayfair parties were able to identify was their demand that Miss Lively limit her request to contacts with specific third party telephone numbers identified in advance. And down here at the bottom, it says here the footnote for that. To crystallize their position as to the subpoena's punitive overbreadth, counsels for the Wayfair parties indicated that the subpoenas, as issued, would problematically reveal whether Mr. Maldoni communicated with 5 mistresses or whether he had communicated with 5 psychiatrists, while a non-content subpoena would not reveal the identity of either mistresses or psychiatrists. It will reveal vitally important information about the phone numbers defendants contacted and when they did so, each of which is highly relevant to Miss Lively's retaliation and defamation claims, as well as being entirely permissible in the course of ordinary discovery. Y'all got to see my face, honey. Blake Lively's team. Now we know that that was used as an overbroad example of how you possibly would be overreaching. But for you to put this in the letter like this, though I respect the petty, I respect the petty because that's real petty. I know you did it just for petty reasons. Because what are you trying to imply? Because again, the way the way public tide is going, they're not rocking with you. They're just not rocking with you. So was this in an effort to put out there that Justin Baldoni has mistresses and several, in other words, that he's cheating on his wife and that he's mentally unstable? Let's continue. Getting back into the body of the letter. As Ms. Lively's counsels noted, such a limitation is inappropriate given the purpose of the specific discovery sought and the purpose of discovery generally. The burden of persuasion in a motion to quash a subpoena is borne by the movement. And then they go into quote different court cases. The Wayfarer parties have fallen far short of that burden, making instead only, quote, general and conclusory objections as to the overbreadth of the subpoena, initially going so far as to assert that no case law needed to be shared with counsel for the Lively/rental parties on this issue. Courts in this circuit have consistently held that it is insufficient for movements to make only general and conclusory objections in the context of a motion to quash. The Wayfarer party's most recent letter underscores their fundamental misunderstanding of the fact that discovery of carrier records is not only permissible, but routine in federal litigation. In the words of their own cited authority, the only question before the court is whether the disclosure of the telephone records is, quote, reasonably calculated to lead to the discovery of admissible evidence. Here, the parties are at the outset of discovery. Ms. Lively seeks communication among the Wayfarer parties and specified other individuals who have already appeared on communications, trying them to the performance of publicity, crisis, or digital services for Baldoni or Wayfarer. Such information is reasonably calculated to lead to the discovery of admissible evidence regarding communications not only among the defendants, but among the larger network of individuals who perpetrated the quote, untraceable campaign. Ms. Lively and in Sovereign Partners, the quote requested records fit easily within this broad definition of relevance. The Wayfarer parties' baseline objection to the production of carrier records that they reveal communications with others fails to acknowledge that there are no privacy or privileged interests in such information. And they go on to quote different things. So they're wanting, they're still quoting. The Wayfarer parties have not identified legal authority standing for proposition that subpoenas to telecommunication carriers must or even should be limited as they propose, and to the contrary, courts regularly permitted such discovery. Moreover, the Wayfarer parties continue to fail to address their lack of standing to assert such objections on behalf of the non-party individuals whose information is sought in the subpoena. In the interest of resolving the parties' dispute and notwithstanding the appropriateness of the initial subpoenas, last week Ms. Lively provided through counsel notices of intent to serve modified subpoenas to AT&T, Verizon, and T-Mobile US. The modified subpoenas removed the request for locational data, further tailored the applicable time periods, and specify on their face that they seek only basic subscriber information, that is, call logs and text logs reflecting non-content numerical information regarding ingoing and outgoing calls or text messages related to identified telephone numbers over specific time periods. Notwithstanding defendants' continued objections to those modified subpoena, Ms. Lively stands ready to issue them pending resolution of the present motion by this court. Those modified subpoenas, like the initial subpoenas, are reasonably calculated to lead to the discovery of admissible evidence regarding such matters as pattern of communications among the Wayfair parties and unknown associates during Ms. Lively's alleged harassment, as well as the inception, duration, and scope of the untraceable retaliatory campaign against her as followed. And it's respectfully submitted by Michael Gottlieb. So let's see. So they've answered Justin Baldoni's request to have a letter. But baby, reading that first footnote, y'all are, though I appreciate the petty, y'all was real petty for that. And I don't think if you're trying to change the tide of social media and how the public is viewing you at this point, I don't think that that was going to help. That just only kind of made it seem like, you're a little too snarky. Y'all put that information in there, even though as you said that it was given to you by the defense. Still, it's not going to help your situation as much. All right, people. We have read the letter, so again, this is a back and forth and back and forth and back and forth, and we will probably continue to see this back and forth until whatever. This is a mess. This is such a mess. It's a good mess for us that are content creators, but still in all, it's a mess. Y'all, I did a live last night with Lauren Victoria Burke talking about this same topic. Go to my community post. You will see the link to that. Go check out our live. It was quite informative, and we had a lot of fun doing it. Also, again, shout out to Leanne Newton out on X for having the documents available so that we can read that. I really do appreciate that. All right. We do this every week. Y'all, please like, comment, and subscribe. Please share this video if you care. Y'all, please tell a friend, tell a kin, tell a coworker, tell that heifer that you can't stand that I'm over here making these videos. And hit that like button and subscribe. All right, people. As always, bye-bye.